Morning, Chair.
She's trying to get me one of the files, but I think we can start. We can start, Mr. President.
Thank you, Chair. This morning, Mabuza attorneys representing the former President, Mr. Zuma, addressed a letter to the Commission to inform the Commission that, quote, as a matter of courtesy, our client will not be appearing before the Commission on 15 to 19 February 2021 for the reasons set out below. Two reasons are given. The first is that there is
One second, Mr. President. Yes, Mr. President.
Two reasons are given. The first is as follows. The Commission is aware that the review application which President Zuma has instituted to set aside the refusal by Deputy Chief Justice Zondo to recuse himself from hearing matters concerning him and his family is yet to be determined by the court. I just point out briefly at the moment, perhaps there'll be more to be said about it later, Chair, by yourself, but for the moment, that application was put before the Constitutional Court. The Constitutional Court was aware of that application and notwithstanding that granted the order that it did, compelling Mr. Zuma to appear today. The second point raised is the following. The summons issued for our client to appear on 15 to 19 February 2021 is irregular and not in line with the fourth order of the Constitutional Court judgment of 28 January 2021. Well, Chair, that's not for Mr. Zuma or his attorneys to decide. That is a matter for the Constitutional Court and any contempt application that may emanate from these proceedings. But it does seem to ignore the application or potential application of the principle that the issue of summons would be valid until set aside by a proper court. And that's a principle applied by our court time and time again. And then in paragraph 5, the letter said, appearing before DCJ Zondo in the circumstances would undermine and invalidate the review application over his decision not to recuse himself. Well, no doubt the courts in due course will deal with that issue.
Do they care to explain why, if Mr. Zuma thought that the fact that he intended to launch a review application against my decision not to recuse myself, why they thought he should not put that before the Constitutional Court when the Commission applied for an order to compel him to.
Well, they say in paragraph 6 that that review application was not before the Constitutional Court. It was not before the Constitutional Court in the sense that the Constitutional Court was not asked to decide that application, but certainly they're incorrect insofar as they suggest that that application wasn't properly pleaded and wasn't put before the Constitutional Court and they were aware of it. So there's no explanation given beyond the bare statement. But that's a matter that the Constitutional Court will no doubt decide. On the face of it, it has no merits whatsoever. But what is not correct in the approach of the former president is that he should come here and express a lawful reason why he should not apply the law or attend in accordance with the summons.
Well,
or set the summons aside prior to.
When the Commission launched an application, its application to the Constitutional Court, Mr. Zuma was served with a full set of papers.
Correct.
And his attorneys were given a courtesy copy, as far as I recall from what I was told, to say here is a full set of court papers that will be or have been served on your client. Now, in that application, the point is made quite clearly that the Commission was aware that Mr. Zuma intended to launch a review application in regard to the recusal application, and it was contended by the Secretary of the Commission that that would be no ground for him not to appear before the Commission in the meantime. So he and his lawyers knew that this was one of the points that were being made by the Commission before the Constitutional Court. And if they contested that, it was up to them to file papers in the Constitutional Court and say the Commission is wrong. The position is that as far as we are concerned, if there is a review application we are still intending to file in the High Court, the Constitutional Court should not order our client to appear. Mr. Zuma chose not to oppose that application, notwithstanding the fact that he knew that that was one of the points that the Commission was going to make before the Constitutional Court.
Yes.
He and his lawyers sent a letter to say he would not participate in those proceedings at all. The question is, can he complain about the order made by the Constitutional Court in circumstances where he was given a full opportunity to oppose that application and place before the court his case and elected, and he elected not to do so.
Yes, Chair. Chair, we could use much stronger language, but perhaps that would be appropriate, more appropriate in time. But the failure to appear today does not appear to be justified by any valid reason, certainly not the reasons given in the letter addressed to the Commission as a matter of courtesy this morning. Firstly, the review application matter was before the Constitutional Court. It was raised in pleadings before the Constitutional Court. And notwithstanding the Constitutional Court's awareness of it, and notwithstanding Mr. Zuma's failure to address the issues at all, the order was given that he must appear. In relation to the summons not being a valid summons, well, that Mr. Zuma was free to come here and say today, but chose not to. And as we know, such a summons must, as a matter of law, be valid until set aside by a proper court. People can't just form their own views as to what the law might or might not say and decide what to do in the face of a validly issued summons, or even a summons which on the face of it is validly issued. That is valid until set aside. So there's no basis whatsoever for the, certainly expressed there, for the President not to be here today.
If Mr. Zuma or his lawyers were of the view that the summons was irregular, the law obliged him, if he wanted not to be obliged to appear, to approach a court and ask that it be set aside on the basis that it was irregular. And I don't know the law to be that he's entitled to just ignore a summons just because he thinks it's irregular.
Correct.
And I think that the principle you have articulated is the same principle that the Constitutional Court told him about in the Nkandla matter, that you can't just ignore a process issued by a lawful body requiring you to take certain action, and just because you think it's wrong, you just sit back and ignore it.
In any event, Chair, 2 points need to be made from what appears to be in the public domain. The real reasons for non-appearance are not expressed in that letter. And they are matters that are perhaps beyond the realm of this commission. This commission has a mandate, a job to do, it must do it. The implications and consequences of this commission doing its job is for those who will receive the report ultimately to decide. The second point is that whatever merits there might be, and we don't see any in the reasons not to appear today, will no doubt in due course be decided by our courts once again.
Have you got the media statement that he issued on the 1st of February? Have you got it at hand?
Yes, we can get it.
You see, the letter from his attorneys this morning says in the last paragraph that, in effect, his non-appearance should not be construed to suggest any defiance of a legal process, but my recollection of his media statement of the 1st of February is that, in his own words, he said he was going to defy the summons of the commission, and he was going to defy an order of the Constitutional Court. That were his words. The media statement was not issued by his foundation. It appears to have been issued by himself.
Yes, Chair, in fact, the statement, it's a long statement, but if I could just place on record certain paragraphs in that statement. He says, I therefore state in advance that the Commission into allegations of state capture can expect no further cooperation from me in any of their process going forward. If this stance is considered to be a violation of their law, then let their law take its course. I do not fear being arrested, I do not fear being convicted, nor do I fear being incarcerated. And then the last paragraph reads, in the circumstances, I am left with no other alternative but to be defiant against injustice as I did against the apartheid government. I am again prepared to go to prison to defend the constitutional rights that I personally fought for and to serve whatever sentence that this democratically elected government deems appropriate as part of the special and different laws for Zuma agenda. Well, certainly that is, to put it at its mildest, a statement of defiance. But once again, Chair, it does appear that the true reasons for not appearing are beyond these strict terms of reference, which we must investigate.
Well,
they are of a political nature.
Well, the Commission is interested in what reasons have been given, insofar as they have been given for his non-appearance. And that media statement seems to make it clear that he had decided to defy the summons, to defy the order of the Constitutional Court. And of course,
the law.
And the law. And that seems consistent with his conduct before this commission on the 19th of November, when he had been issued with a summons. He came to the proceedings and left at a time when it had been made clear to him and his lawyers that to leave the commission without the chairperson's permission would be a a breach of the summons and a breach of the Commissions Act. His foundation, it's in the public domain, issued a media statement on the same day saying it had been assured by him that he would rather go to jail than appear before the Commission. So the media statement that he issued on the 1st of February after the Constitutional Court had issued had handed down its judgment and ordered him to appear before the Commission and to comply with all summonses and directives issued by the Commission. The statement that he gave is consistent with the Jacob Zuma Foundation's media statement of the 19th of November, 2020.
Yes, Chair.
And in the founding affidavit deposed to by the Secretary of the Commission in the application that was made to the Constitutional Court, one of the points that was made was that reference was made to the contents of that statement by the Jacob Zuma Foundation of saying he was going to, he was not prepared to appear before the Commission and he would rather go to jail. And he, that is Mr. Zuma, was invited to distance himself from that statement by his court, his foundation. He has never distanced himself. Yeah. Instead, in his media statement of the 1st of February, he confirmed that he was going to defy not only the summons of the Commission, but also an order of the highest court in this country.
Yes. Chair, in summary, the reasons for non-appearance couched in courteous and polite language in this morning's letter from Abuza attorneys don't seem to hold any water and are groundless. But those comments there, in particular the comment that nothing should be construed so as to suggest any defiance of a legal process, must be read in the light of the statements to which we've just referred. And in particular concern is the reference to their law. In other words, not a law by which I will be bound, but a law that will bind others. And if there's any act of defiance, it's contained in those two words.
Yes, continue.
Chair, the legal team has prepared an address to deal with the very circumstances that have now arisen, and if I could take half an hour or so
yes.
to just inform the Chair and the public of the types of issue that would have been raised
yes.
Had Mr. Zuma elected to obey.
I think that is important because it's important that everybody understands at least the important features of what has happened
yes.
and how we have come to be where we are.
So what this address will deal with is really the evidence before the Commission and what issues would have been placed before Mr. Zuma for his response or input in order to assist you to come to findings in accordance with your mandate and your terms of reference, Chair. We don't intend to deal with the legalities of the non-appearance and the consequences of Mr. Zuma's failure to appear as a matter of law. In short, Chair, the Commission has now been deprived of its opportunity to question the former President in regard to his knowledge of and his conduct relevant to the Commission's terms of reference, which I will detail in a moment. But by way of summary, where we find ourselves now is that we have terms of reference, a mandate to you, Chair, and to the Commission as a whole, Mr. Zuma is referred to directly by name in 4 terms of reference and indirectly in 2 as part of the executive, or at least 2. His evidence is obviously relevant to the Commission's work in this regard. There can be no doubt about that. Mr. Zuma has also been implicated to date by the evidence of at least 40 witnesses now. Now, whether Mr. Zuma believes he has been accused of wrongdoing or not, which appears to be the case, his responses to those allegations are still directly relevant to the work of this Commission. Numerous statements have been made by or on behalf of Mr. Zuma that he has not been implicated in any wrongdoing by any of the witnesses that have thus far come before you, Chair. If that is so, if it's so that Mr. Zuma believes he has not been implicated of any wrongdoing or accused of any wrongdoing by any evidence before you, Chair, then it's difficult to understand why he would need to rely on a right to silence.
And also, it's difficult to understand why he would be scared of taking the witness stand and subjecting himself to questioning like everybody else.
Correct.
By the evidence leaders and the chairperson.
And still less, Chair, would Mr. Zuma need to rely on any right against self-incrimination if, on his version, there's no evidence which indeed incriminates him. So the alleged interference with his constitutional rights seems, on his own version, to be entirely groundless. Be that as it may, what happened during the presidency of Mr. Zuma and during the period under review, the details of what he did, the details of what he didn't do, and importantly, his knowledge of events, whether direct knowledge or indirect knowledge, are important for the work of this Commission. Moreover, he was not only during much of the period under review, not necessarily all of the period under review, President, he was Chair of Cabinet. Cabinet made important decisions. Cabinet, on the face of it, failed to take important decisions. The exercise of his responsibilities in these capacities are important to the work of the Commission. Finally, Mr. Zuma and members of his family are alleged to have received substantial monetary and other benefits from private and state sources. These also require a response and an explanation. In short, Chair, Mr. Zuma, perhaps more than anyone else, is able to assist the Commission in understanding what happened in the period under review, how it happened, and what recommendations the Commission should make in relation to its findings. But clearly this assistance is not forthcoming. This is not an attack. It's a calling to account and a calling for assistance and information to enable you, Chair, to fulfill your mandate. The Constitutional Court made a finding in December, Chair. It said, or January, it must be plainly stated that the allegations investigated by the Commission are extremely serious. If established, they would constitute a huge threat to our nascent and fledgling democracy. It is in the interests of all South Africans, the respondent included, that's Mr. Zuma, that these allegations are put to rest once and for all. It is only the Commission which may determine if there's any credence in them or to clear the names of those implicated from culpability. There are 2 aspects to a Commission of Inquiry, certainly in these circumstances, Chair. The first is to investigate its terms of reference, to hear evidence in relation to its terms of reference, and to make findings and recommendations in relation to that. But it's also there, Chair, as a matter of public concern, and this was stressed by the Constitutional Court. The public have a right to know what happened. The public have a right to know what their president did or didn't do. The public have a right to know what their president says about this. Not in the streets outside residences in KwaZulu-Natal, but here in this commission. So the duty to assist the commission, Chair, is not only a legal duty arising from the summons issued by the commission. That's the narrow legal issue which is before you, Chair.
Well, in talking about the duty to assist, if I recall correctly, paragraph 3 of the terms of reference of the commission, which were signed by him while he was president, in paragraph 3 of the terms of reference, he said all organs of state will be required to cooperate fully with the commission.
That is correct.
One would have thought that he would be the first one to cooperate fully with the commission.
Yes. Well, at the time, too, he made a public statement announcing the establishment of the commission and urging all South Africans to cooperate fully. And that clip is in the media. Apart from the duty to obey the summons, apart from the duty to abide by regulations, terms of reference and the like, there's a constitutional duty arising from the position that Mr. Zuma held as president of the country. It's also a public duty owed to the citizens of this country. Manifestly, this commission's work is a matter of public concern. So, Chair, whatever the politicians and commentators might have to say about the Commission's work, it remains our duty to fulfill the mandate that you've been given, Chair, in accordance with your terms of reference. And it's these terms of reference that guide its work. We simply have to do our duty. So whatever the noise out there, Chair, we, yourself as a sitting justice and ourselves as evidence leaders and the investigators, we have a mandate. It's a legal mandate, and we must obey that mandate. And that is our duty, and we must fulfill it. The legal consequences of Mr. Zuma's failure to appear will no doubt be dealt with separately, and perhaps, Chair, you will deal with those in due course. But I would appreciate, Chair, and have been requested by yourself to inform yourself, the Commission, and the public of the issues the legal team intended this week, and perhaps an additional time to raise with Mr. Zuma. Chair, there is a need for a caveat, however. It seems that many don't understand really how the Commission goes about it. It hears evidence, does not tell people what to say. It may highlight topics that need to be covered, but ultimately the witnesses come here to give their evidence. That evidence can be contested by other witnesses. In the fullness of time, and when you do your report, Chair, you will decide who is telling the truth and who is not telling the truth, and we can assist you in that regard. But the allegations that we will outline now in this address, Chair, are based on evidence presented, as well as evidence still to be presented, allegations which have emerged in investigation, statements which have been taken. The correctness or the veracity of that evidence will only finally be determined after you, Chair, have considered all the relevant versions received in respect of the evidence, including what we thought might be the version of Mr. Zuma. Some of the allegations, as I've said, that will be referred to have not yet been led in evidence, but Mr. Zuma has been notified of such allegations in voluminous correspondence with him and his attorneys. All those allegations would in the ordinary course be the subject matter of notification to Mr. Zuma before being questioned thereon at a later stage. So even if this week we were constrained to deal with certain issues in relation to which Mr. Zuma had already been received information and been notified. At a later time, he would have to answer other questions or be asked to answer other questions in relation to allegations that are the subject matter of the Commission's investigation. Chair, but the essential thrust of the questioning and discussions with Mr. Zuma this week is based on the ultimate question, really, that the legal team would like to assist this commission to answer. In August 2018, the legal team made an opening presentation to the commission. And in that opening presentation, it was emphasized that state capture is not just about corruption. The mandate to inquire as to what is state capture and whether state capture was a project which was perpetrated by whomever might have been implicated in the evidence. It's a question that is yet to be answered. The work of this commission is not even about widespread corruption. Corruption itself may be a part of a project of state capture or an alleged project of state capture. But state capture is more than that. State capture, and this was in the opening statement in 2018, at least in theory would concern a network of relationships, both inside and outside government, whose objective would be to ensure the repurposing of government departments, officials, and state-owned entities for private and unlawful gain. In other words, when one puts together all the elements, the evidence that you have heard, the question is, what does this mean? Is it just corruption? Are these just ad hoc events that seem to coalesce in a period of time, or is there something more to it than that? And that is what would have been explored with Mr. And that is ultimately a finding that you would have to address in your report. So the submission was made that the work in 2018, Chair, by the legal team, that the Commission was obliged to investigate circumstances where the allocation and the distribution of state resources is firstly determined by a network of persons outside and inside government acting contrary to constitutional and legal norms. Secondly, directed not in terms of our laws and policies to what should have been the outcome, but for the promotion, protection, and private financial gain of beneficiaries of that network of persons inside and outside government, and facilitated that project. Question arises, was that project, and this was put as a question, not as an answer, was it facilitated by a deliberate effort to exploit or weaken key state institutions, for example, law enforcement agencies, or even Parliament in its oversight duties? Finally, Chair, what would have been, at its broadest, the question, not the answer, the question put to Mr. Zuma is, how does one make sense of it? What really happened? Not the little pieces of the jigsaw, but looked at globally in its whole conspectus. What happened? And secondly, how could that have happened? How could it happen, for example, that this corruption wasn't picked up and prevented by law enforcement? How could it happen that the various constitutional oversight bodies failed, at least initially, to deal with what was going on? Really, what happened and how could it happen? And only with a full understanding of that, with the assistance of Mr. Zuma, honestly and openly speaking to the Commission, could one take the next step towards recommendations. To go into some detail now, Chair, against that general background, Mr. Zuma would have been asked to respond in detail to allegations regarding his relationship with the Gupta family in South Africa. And there are many factual issues which arise under this head that would require some discussion and examination. So, and obviously, in the short time that we have this morning, I'm not going to deal with every issue, but mainly to highlight certain important issues. There has been evidence led over 3 years relating to the knowledge and involvement of the Gupta family in actual or contemplated ministerial appointments and dismissals. We've heard the evidence of Ms. Mentor, Mr. Jonas, Ms. Hogan, Mr. Gagaba, Mr. Mbalula, Mr. Gordon, Mr. Nene, and Mr. Des van Rooyen, to name but a few. All of them.
You said Mr. Gagaba? Well, I haven't heard him yet.
Yes.
Yeah.
Well, there are allegations.
There's
that would
evidence
be put to
against.
Yes.
There are allegations involving
There are
him.
allegations that he would answer in this realm. As I said in the beginning, this includes evidence already led and to be led, on the understanding that before being called to answer, he would have been informed of it for a later appearance. So, in relation to the appointments and dismissals of ministers, now this is just one piece of the jigsaw. What flowed from the appointments and dismissals of ministers, I will deal with in due course. But that's the starting point in the center of the jigsaw puzzle. The evidence has been that the Guptas had, in some cases, prior knowledge of executive appointments and dismissals in our terms of reference, specifically and expressly. The Guptas sought to influence executive appointments, on occasion through bribery or attempted bribery. The Guptas sought to gain business advantage from relationships with and access to ministers, and I'll come to detail in a moment, but that's at a general level. What is also clear, and that is the next step in the puzzle, the Guptas and Gupta-related entities ultimately benefited substantially from manifestly corrupt or irregular procurement deals. That is the evidence. Those are the allegations made before you. You will make a finding on the correctness of those allegations in due course. And this followed what may be termed a new level of repurposing, not at executive level, but at the level of state-owned entities. And the allegation that would have been put to Mr. Zuma is that by reorganizing or repurposing state-owned entities, principally through appointments and dismissals, in relation to which, at least in some cases, Mr. Zuma's involvement was direct, that was arranged to redirect state resources into hands of select individuals and entities, including Gupta entities. And these beneficiaries included members of Mr. Zuma's family, so the allegation goes, and I stress these are allegations, principally Mr. Duduzane Zuma. So, Chair, there is substantial evidence requiring an answer before you make your final decision, and I stress that once again, that we are dealing here with allegations that are before this commission that must be dealt with in the fullness of time. Mr. Zuma involved himself...
Well, strictly speaking, where evidence has already been given, it's really more than allegations, it's evidence.
It's evidence.
It's evidence now. It's been given under oath, and some of those witnesses have subjected themselves to questioning on their evidence. So it's evidence that has been placed before the court, so it's before the commission, not the court. It's no longer just mere allegations that are made in the streets.
Well, perhaps it would be fair to say that in the course of evidence under oath before you, which has been tested to an extent, certain allegations have been made which require an answer.
Yeah.
At the end of the Commission's work, insofar as the leading of evidence is concerned, whether in oral or documentary form, you will then determine the outcome. Okay. So there's substantial evidence, Chair, and I'll detail that in a moment, that Mr. Zuma involved himself directly in the affairs of state-owned entities. Executive appointments were followed, and executive, I'm talking of cabinet appointments, were followed by appointments of, amongst others, boards of and senior executives in state-owned entities. And this happened by way of example, Eskom, Transnet, Denel, Prasa, SAA, all that evidence is before you. The consequence, what happened then in time, is that there has been evidence of vast acts of corruption, which took massive resources out of those state entities and placed them in the hands of those very entities and persons who influenced this whole process of repurposing. The question is, was this just a coincidence in time? Is it simply a coincidence in time that after the ministerial appointments and dismissals, and after the replacement of boards and replacement of executives, vast corruption is alleged to have taken place? Is that a coincidence? Or was the outcome intended at the time the reorganization or repurposing took place? That is the key question in relation to whether state capture took place or not. So, for example, Chair, if we may drill down to another level of detail and deal with Eskom. In Eskom, the evidence had been that at the time Ms. Barbara Hogan was relieved of her duties as minister, Mr. Zuma interfered directly in SOE executive appointments and dismissals, and one example is that of Mr. Jacob Zuma. What was the purpose of the intervention there, is the evidence. And why would a president interfere, as the allegation was, in who should be appointed, whether Mr. Moroka's resignation should have been accepted, and for what purpose? Why was this done? There's also been evidence, Chair, substantial evidence more recently that during the latter years, much later than the incidents revolving around Mr. Moroka's resignation, that the former president involved himself directly in the suspension of senior Eskom executives and their ultimate replacement by others. That evidence you have asked Mr. Zuma to respond to in 10.6 directives, which are legally binding. Those 10.6 directives asking him to respond to that evidence have been completely ignored. Once again, why would a sitting president, this would be put before Mr. Zuma, involve himself in meetings with executives and others to determine the content of a board or senior executives, in this case, of a state-owned entity? What was the purpose of that? We know what happened afterwards, after the repurposing, under Mr. Zuma's watch, that corruption occurred, redirection of state resources occurred. The question is, was there a link? Was the outcome intended by the repurposing or through the repurposing and reorganization? So evidence has also been led, one will recall at the beginning, the influence or alleged influence of the Gupta family in ministerial appointments and dismissals and others too. We know that ultimately financial benefits in a reorganized state-owned entity flowed to the Guptas and Gupta-related entities. Again, was this just coincidence in time, or was it this a planned series of acts to achieve the outcome that actually happened? And this, Mr. Zuma could have assisted you in answering that question. We also have evidence, Chair, of cash. During this period under review, being given to and taken away from the Saxon World residents of the Guptas by a number of key personnel in the state-owned entity stables. Now, if one takes these events, the attempts to influence executive appointments, the attempts to, and I mean cabinet, executives at the cabinet level, appointments and dismissal, the consequent effect that that reorganization at the highest level had on the composition of boards and executives in state-owned entities. The outcome of that, the allegations of the illicit flow of money out of these state-owned entities to the very influencers that sought in the beginning to set this train of events in motion. Question is, are these random and ad hoc occurrences in a sequence of time? Or are they part of an organized project to redirect state resources into private and individual hands where these are illicit receipts? Transnet, Chair, is another example. Again, Mr. Zuma appears to have involved himself directly in executive appointments. Ms. Hogan led extensive evidence, some of which has been dealt with, but not entirely by Mr. Zuma, of Mr. Zuma's actions in the contemplated appointment of Mr. Siyabonga Gama. Great. According to the evidence, Mr. Zuma went to great lengths to bring this about, despite what was happening at the hands of the board within Transnet. The appointment of Mr. Brian Molefe as Transnet Group CEO appears to be known beforehand by the New Age newspaper, a Gupta entity. How could this happen? What are the implications of this evidence? Was there an organizing hand in this whole sequence of events? Again, Chair, there's substantial evidence of a repurposed Transnet being exploited through corrupt procurement deals for personal gains, including that of the Gupta-related entities. Denel, by way of example. There's evidence that through appointments and dismissals at board and executive level, Denel was reorganized under the minister at the time, Minister Lynn Brown. And that includes the appointment of Mr. Dan Muncher, Mr. Zuma's former attorney, as chair of the Denel board. Did Mr. Zuma have any hand, know of it? What was the position there? But again, after the reorganization, after the change in personnel, one has, is it a mere coincidence in time? You have the VR laser matter, where at great cost to a state-owned entity, Denel, a Gupta-related entity, VR Laser Asia, is dealt with by Denel. Great cost to Denel, but great benefit to a Gupta-related entity. Again, is this merely a coincidence in time, or was it part of an intended plan, and was it an intended consequence? Because now the evidence is building up there. You have Eskom, you have Transnet, you have Denel. PRASA, the same pattern occurs. Evidence of appointments of a chair and CEO under whose watch significant acts of corruption have been alleged and reported. There's also been evidence of attempts to, quote, clean up PRASA, unquote, being hampered by a lack of support from the ANC top six, including Mr. Zuma. And that's an explanation required not only from Mr. Zuma, but from others as well who were part of the top six at the time. Not enough to say, well, they had the power to deal with it, they should have dealt with it. I mean, that's the most extraordinary statement that emerged from that evidence by a senior ANC politician who simply said, yes, we were told of the corruption by Mr. Molefe, but they had the power to deal with it. Really extraordinary. And then there has been evidence of a company, and this evidence is part of the evidence quite separate from evidence that was sought to be led in relation to benefits that company linked to Mr. Zuma or a company linked to someone who paid Mr. Zuma money received benefits under the PROSA banner. But that's another issue that would have been raised. But again, there's evidence that payments were made to Mr. Zuma arising out of procurement deals in the PROSA stable. SAA, similar type of evidence, South African Airways, particularly the protection that is alleged to have been afforded to Ms. Dudumiyeni as chair of SSA, who we know had a very close relationship with Mr. Zuma, and these allegations would have been put to him, and he would have been asked for an explanation in this regard. Now, Chair, these examples in relation to state-owned entities are by no means exhaustive of the evidence laid before the Commission. But, as I've said, what requires consideration ultimately by you, Chair, after evidence from all concerned, is what is the connection between the attempts to influence appointments and dismissals of the Cabinet, the appointments and dismissals that actually took place at Cabinet ministerial level, the appointments and dismissals that took place at state-owned entity, board and executive level, and the substantial corrupt dealings, evidence of substantial corrupt dealings which followed. The question that would have been put to Mr. Zuma is what was your involvement, your knowledge, your action, your lack of action in relation to this? Was this just, as I've said, a coincidence, a sequence of coincidental actions which began with attempts to influence appointments at the most senior government level, through to board executives, and, boards and executives of state-owned entities, through to corruption, through to the benefits that came back to those that sought to influence this course of events in the first place? Was that an organized project? Was the outcome intended when these appointments and dismissals were made? Were the persons who were appointed subject to influence that could have assisted in the redirection of state resources in the manner in which it was done? That's as far as state-owned entities are concerned. As far as government departments are concerned, similar evidence, similar pattern of evidence has been put before you. There's been substantial evidence of attempts to reorganize or repurpose government departments. Again, the evidence appears to state that this was done for the improper business advantage of select individuals and entities. Now, that is put at the most general level. Some of the detail, in minerals and energy, you've heard evidence, Chair, from former Minister Ramatlodi, that he was pressured to meet with and to favor Gupta-linked operations, again improperly, within the mining sphere. The allegations are to the effect that reports were made to Mr. Zuma in relation to these attempts. Did he approve? Did he act? Did he fail to act? In each case, why? What was the purpose of that approach? These attempts were resisted by Mr. Ramatlodi. He was removed as minister. Mr. Zwane was then appointed as minister. Attempts were made to appoint Mr. Jimmy Manye as Director General. These attempts failed. But these figures appear in other aspects of the evidence too, particularly in relation to communications and the Government Communications Information Service, the New Age newspaper and the like. I'll deal with that in a moment. So, after Mr. Zwane's appointment, there is evidence that steps were taken to favor the Gupta's mining interests. Some of those activities, the evidence suggests, were irregular and unlawful. There's the remarkable evidence of one of the former members of the SSA to the effect that, to the knowledge of the President, a meeting was held in the President's private study in his residence in Pretoria, where one of the Gupta brothers accosted Ms. Susan Shabangu about her failure to meet the desires of the Gupta family and its entities in relation to the mining issue. That evidence is quite extensive, but again shows that to the knowledge of the President, pressure was put for illicit and unlawful favoured treatment within the Minerals and Energy Department. National Treasury, the matter of great controversy, especially beyond the four walls of this venue, Chair. But as was made clear by Mr. Nene, National Treasury is important because it finances deals, procurement deals of a large nature. It does have a supervisory procurement role to play, and it is in a sense an oversight body in this regard. It does have regulatory power over how government's financial resources are used. So Treasury is, and the evidence is that it was, a stumbling block to irregular procurement deals and the irregular expenditure of state resources. And what is clear is that, again, the former president, the evidence goes, sought to influence or exert pressure on Treasury officials, ultimately removed two ministers, and the evidence goes, stood in the way of a deal involving Petro SA, where it wished to buy Engen refinery. What it didn't wish to. The pressure came from above that a deal should be done at great cost without a due diligence exercise for an overpriced Engen refinery from the Malaysian owner Petronas. That evidence would have been explored. The nuclear deal and the activities in Russia, where Minister Nene was involved and gave evidence as to pressure put on him. What happened at Cabinet? Why was this deal contemplated in the first place without sufficient background information? Why would the information only be investigated after an in-principle decision was made in Cabinet? This is something that not only Mr. Zuma would have to answer to, but other members of Cabinet as well, and it will in due course be done. Mr. Zuma is not the only one who was part of such decisions. That is a matter that could have cost the country dearly, as we've heard. Why? The request by the chair of the SAA board, Ms. Dudu Mieni, to open a new SAA route to Khartoum. Again, direct involvement in placing pressure there. There are other examples. Chair. The closure of the bank accounts is another area where private banks took steps to close Gupta and Gupta-related entity bank accounts. And there was a ministerial task team appointed. In essence, the evidence goes to oppose and to prevent that outcome. And there's been substantial evidence in relation to that. Interestingly and significantly, there were at least two incidents of centralization of power under the presidency and under the State Security Agency, and I'll come to the latter point in due course. But there has been evidence that Mr. Zuma initiated a process to remove the national budget process from Treasury and to place it in the hands of the President. And the reasons for this require some investigation and explanation. Chair, the removal of Mr. Nene as Minister of Finance by Mr. Zuma has been dealt with in evidence. That took place in December 2015. And that took place at a time when, according to the evidence, Mr. Nene stood in opposition to the nuclear deal. Was there a relationship between the two? That question needs to be put, needs to be answered. The stated reason that Mr. Nene's deployment was required to the BRICS Bank has been seriously questioned in evidence by more than one witness, that it simply was an unconvincing and some say spurious reason. There were other reasons. What were those reasons? And were they part of this overall plan that emerges or possibly emerges from all the evidence? It also appears that the Guptas had foreknowledge of Mr. Nene's removal. And there was an alleged complaint on their part that Mr. Nene would not, quote, work with them, unquote. That evidence also before you, Chair, needs explanation and answer. And it was shortly before Mr. Nene's removal that, according to Mr. Jonas, there was an attempt to bribe him to take up the role of Minister of Finance. Again, that evidence is before you. And that evidence needs to be dealt with. These are the friends, close friends of Mr. Gupta, close friends of Mr. Zuma and his son and others in the family, but particularly Mr. Dubuzane Zuma. What was going on here? What are the links? What was the purpose behind all these appointments and dismissals? And were they to facilitate the outcome that we know actually occurred? Then there are the circumstances surrounding Mr. Gordon's removal by Mr. Zuma, his sudden recall from London. There has been that evidence. Those too require clarification. Where did this supposed state security document, Operation Checkmate, come from? What was its status? We know the evidence is that that document was put before the top six, but its contents were rejected, and then other reasons were stated. But what was it? Why was this done? Why was it necessary to change the incumbent of the ministry there? The outcome and consequences, were they intended? So the access to and use of a supposed intelligence document in an apparent attempt to justify Mr. Gordon's dismissal requires some explanation or clarification. We know that Mr. Zuma then sought to replace Mr. Gordon with Mr. Brian Molefe. And we know that he'd had a recent and eventful journey through Eskom and Transnet with all that happened during that time. We know that the top six objected strongly and that Mr. Gigaba was appointed instead. But those questions need to be explored. Again, to answer the question as to whether these are all coincidental, these individual pieces of evidence which ultimately pile up and appear to point in one direction, is that a fair conclusion? Was the outcome intended? The appointment of Mr. Gaba's deputy, Mr. Buthelezi, is another one issue that requires some investigation, particularly as Mr. Buthelezi had been implicated in allegations of serious malfeasance at PRASA, and Mr. Zuma was aware of it. South African Revenue Service is another example. We know that there is evidence, perhaps to come, of Mr. Zuma's direct relationship with Bain Incorporated. And the term of Mr. Miyani as the SARS head and the involvement of Bain and Company in the supposed restructuring of SARS is well documented in the Newton Report as having a disastrous outcome. But why? You know, Mr. Zuma, did you have any personal involvement? What was the object of your personal involvement in your dealings with Bain and with Mr. Miyani? the outcome, was that an intended outcome? We know, for example, that the Gupta family benefited from dubious decisions of SARS regarding controversial tax treatment, but that's just one of the outcomes. The Waterkloof landing, Chair, that's another question. When all the evidence before you is considered, and all the evidence that was not forthcoming before you is considered, the probabilities will have to be considered by you. And this is a direct issue that needed to be raised with Mr. Zuma. The Guptas are your friends. There is this huge logistical event to occur prior to the Gupta wedding. These are your confidants, your friends. Your son is in close business relations. Not only an aeroplane, but helicopters, police escorts. And Mr. Zuma knew nothing about it. On the face of it, it seems improbable, and some explanation needs to be given. His office was involved in compiling reports thereof. And there is a brick wall between any knowledge that the President had, prior knowledge, knowledge at the time, post-knowledge. And then why would he obviously concur in the appointment of the alleged wrongdoer, the person who took the hit, Mr. Kolwani, getting an appointment to the Netherlands as ambassador? All those facts need explanation because they raise many more questions than just warrant putting the evidence to rest at the level that it was given before you. Just one small issue. Here is a person who facilitated a most serious breach of national security by, on his version, lying and on his version, facilitating the Gupta landing at Waterkloof. He goes with a, no doubt, top security clearance as ambassador to the Netherlands. Lots of questions that require answers. Then there's the Department of Communications and GCIS, the appointments and dismissals that took place there, the need of GCIS to, in effect, finance New Age newspaper through advertising revenue and the like. That evidence also, with the apparent approval, or the apparent action or non-action of Mr. Zuma that requires to be put and explained. But once again, as one goes through all these individual events, a bigger picture begins to build up. And the question we come back to all the time, was this a complete course of action designed to benefit certain parties illegitimately and beyond the prescripts of the law and the Constitution? There's another example, Chair, that's the activities of the SASA and the Department of Prison. Chair, the evidence has been that the SASA relied heavily on government contracts worth on average 2.5 billion rand per annum. There has been direct evidence as to how the SASA bribed government officials, scale of about 66 million rand per annum, I estimate. Mr. Agrisi claims that Mr. Zuma had a close relationship with BOSASA's main shareholder and chief executive, Mr. Gavin Watson, and they met frequently. And there have been a number of allegations that have arisen out of that evidence. BOSASA appeared to benefit Mr. Zuma and the governing party in many ways. There's evidence that 300,000 rand a month was paid in cash to the Jacob Zuma Foundation, usually by handing it to Ms. Dudumieni, but at least on one occasion directly to Mr. Zuma. Mr. Agrisi and others testified that BOSASA paid for and catered for functions worth millions of rands for Mr. Zuma, his family, and the governing party. We know of the election call facility and at least one or even more generous donations to the ANC. Now, in the in themselves, companies do donate to political parties. We know that. The framework within which that takes place, the legal framework may change very shortly, but at the time donation was made, the question is, was there a quid pro quo attached? And in this case, there is evidence of the support, the monies paid directly and indirectly, the bribery. The quid pro quo involving Mr. Zuma, support was sought from Mr. Zuma. Protection from prosecution by the NPA. We know that Bosasa was not prosecuted, despite evidence being before it for a period of many years. That seems to have changed now, but to a limited extent. After being investigated by the Special Investigation Unit, that file lay dormant for almost a decade. That file, concerning the investigation into Bosasa's allegedly corrupt activities, was handed over to Mr. Agui, copies of that file, by Ms. Dudumiyeni, whose expenses, we know in evidence, had been paid for by the Jacob Zuma Foundation. What was the former president's knowledge? He had been asked directly by Mr. Watson to deal with this investigation and prosecution, so the evidence is. What happens is that there is no prosecution. The matter lies dormant. And the file, then, Ms. Dudumiyeni hands over. What is going on here? Is this yet another example of protection, and I'll come to law enforcement agencies in a moment, of protection of malfeasance, of allowing a system to operate without consequence? And so we add Bosasa to the list. We add Bosasa to the pile of allegations. And it's difficult to contemplate that this was all just matters happening in a coincidence of events over a period of time. And that there was not a plan, an intent, and a guiding hand or guiding hands behind it. The Karoo fracking example is another example where Mr. Zuma was asked to intervene to facilitate change in regulations to allow that deal to go through. That evidence has been given, but it's an example of Mr. Gavin Watson, on the one hand, heading an organization that obtained benefits to the tune of billions of rand from state-owned or from government departments, that gave donations and other benefits to members, senior officials within government and the executive, and asked for a quid pro quo and appear to have received a quid pro quo, particularly in relation to the prosecution. Who benefited from this all? There's evidence that Mr. Duduzane Zuma benefited substantially from dealings and his involvement with the Guptas and Gupta-related entities. Again, the question may appear to some to have an obvious answer, but the question needs to be asked. Was it intended in this scheme of events, when one looks at all the occurrences together, again, beginning with attempts to influence appointments and dismissals at a cabinet, flowing down to the repurposing of SOEs, followed by the corruption, the benefits of that flowing back to Gupta-related entities, and entities in which Mr. Duduzane Zuma had an interest. Was that consequence intended? Was it known? Did you do anything about it? Did you allow it to happen, or did you cause it to happen? Those questions need to be answered, and ultimately answered by yourself. Share with as much assistance as you can obtain. There's evidence of direct payments to Mr. Zuma. Okay. The Gavin Watson Bosasa payments, 300,000 rand per month to the Jacob Zuma Foundation. Those require an answer. the approximately 3 million rand paid to the Jacob Zuma Foundation via Ms. Durimieni, that evidence. The payments received in relation to the contract with the Royal Security, evidence would have been given, and a chance to put that before Mr. Zuma would have been afforded. The evidence, again, Mr. Zuma would have been presented with this evidence and given an opportunity to respond or to think about how he would respond of monthly payments. What we know is that there was a project initiated to make payments in a monthly amount of several million rand from SSA funds to Mr. Zuma. There was a project. The question is, was that project implemented to its fullest? The evidence is that that money went to a minister, and it was the minister's, the idea was at least that the minister would hand that money on. There's no direct evidence of that money being handed on, but it's an obvious question to ask Mr. Zuma. Please tell us what happened there. There's also evidence in relation to what happened with the sale of 3 farms, or the purchase and sale of 3 farms. I won't go into detail there for the present. And other benefits. Certainly there's evidence of benefits to the ANC, and it would have been asked, were the Guptas ever asked for favours, and did the Guptas ever grant favours? We know that money was paid by Bosasa for ANC events, and that there's evidence of Prasa assets being used by the governing party at the time of elections. But be that as it may, Chair, there are numerous pieces of evidence. Don't give them. That full picture, particularly the use of cash, which is untraceable by its very nature. And we have evidence, and more evidence to come, Chair, if that evidence comes to light, that much of the benefits, or many of the benefits received as a consequence or outcome of corrupt dealings, in order to maintain, clearly in order to maintain the cooperation of all those involved in this network of individuals, cash was used. Cash is untraceable. There has been evidence, and there will be more evidence. That requires an answer. This use of cash, the allegations in relation to the use of cash at elections and elsewhere, something that we've only scratched the surface of in the investigations, Chair. And it's something that, by its very nature, is difficult to reveal. Then we come to law enforcement agencies, Chair. I see I'm way over time.
We can take the adjournment now, or if you prefer, we can go on and let you finish, and then we take the adjournment. Maybe we should take it now.
Yes, Chair.
Okay. We'll take the tea adjournment now. It's nearly 25 to 12. We will resume at 10 to 12. We adjourn. continue, Mr. Pretorius.
Thank you, Chair. Chair, just to summarize, we have evidence, and you have heard evidence led before you of attempts of particular networks of individuals and entities to influence appointments and dismissals at the highest level. Those decisions ultimately were made by Mr. Zuma in the period under review. That then filtered down into appointments and dismissals and reorganization of state-owned entities and government departments. The benefits from the illegal, unlawful, illicit dealings that occurred during that period was a consequence of that period I've dealt with. Is that coincidence or was that intended? Come back to the very source where the influence was sought to be originated in the first place. But the question then arises, Chair, where were the defenders of our legal order whilst this was all happening? Where was Parliament in its oversight role? Where were the various oversight bodies? We know that the Public Protector intervened eventually, but very late. And where were, in particular, were the law enforcement agencies? And the question arises, were those law enforcement agencies deliberately disabled, deliberately influenced to allow this project, if it was a project, to continue to its logical outcome, to fruition? Or is there some other reason why what happened within the sphere of law enforcement agencies in relation to the evidence that you've been given, Chair, to explain it? And that must be explained, Chair. And there are many who can explain, but Mr. Zuma is one who could assist you in coming to a conclusion in that regard. The evidence is reasonably overwhelming, Chair. You can make findings, but to get a complete picture, one needs the complete evidence. The most stark example is the Bosasa example. I've dealt with it. Investigation, rampant corruption, SIU investigation, dormant for almost a decade. And we know that certain key individuals appointed directly or indirectly by Mr. Zuma or persons acting under Mr. Zuma to interfere with that prosecution. I'll come to some detail in a moment, but that's the starkest example. But there are others. So we know from evidence led before you, Chair, that law enforcement agencies failed to detect, prosecute, and prevent wide-scale corruption during the period under review. Why? Was this just coincidental yet again? Or was it intended that it be so? Law enforcement agencies, the evidence has been, were considerably weakened in the fight against corruption and crime during that same period. It's instructive, Chair, that beyond the period that this Commission has been concentrating on, we refer to it as the period under review, we know from evidence, and it's a fact, that the National Director of Public Prosecutions has a 10-year term. The intent of that is stability and effectiveness and independence. Not one National Director of Public Prosecutions has lasted that 10-year term. There are examples, Chair, of the law enforcement agencies being used to target persons who were intent on combating corruption. The host of that, days of evidence have been given before you in that regard. Conversely, Chair, there are several examples of persons or entities not being prosecuted for corruption when they should have been. Again, sheer coincidence or part of an intended plan. Executive interference in the operation of law enforcement agencies, there's been evidence before you that that has occurred. And again, several dubious appointments and dismissals have been placed before you by way of evidence within law enforcement agencies. Now, we know, Chair, that as President, Mr. Zuma had the power to appoint many of the most senior officials in law enforcement, including ministers of police, the National Director of Public Prosecutions, all provincial and special directors of public prosecutions, the head of Special Investigations Unit, Commissioner of Police, and the Commissioner of the SARS. So those all were direct appointees. I think that is correct, Chair. We know, for example, you've heard extensive evidence of the tenure of Mr. Nkosana as head of the NDPP. And it appears, according to the evidence, that Mr. Nkosana was determined to hold Ms. Jiba and Mr. Mkhwebe accountable for their conduct in a number of cases, including interference in the Bosasa prosecution. Their conduct has been criticized by the courts over and over again. The very person who sought to hold them to account, we know of the circumstances surrounding the termination of his employment as NDPP. Chair, we have numbers of examples in evidence of politically connected individuals being protected from the law. General Mkhudli is one example. You've heard extensive evidence about that. The interference in the prosecution of the Bosasa entity, the investigation and prosecution and the interference in the investigation and prosecution of Mr. Pandey. You've got that evidence. It's clear, Chair, who was a business partner of two of Mr. Zuma's family members. This is something that needs to be raised. It needs to be answered. Why were politically connected individuals apparently protected by law enforcement agencies? From the very top, why were those appointments made? Why was this not detected? Why was it not dealt with? The glaring question, of course, is there can be no doubt that those in power knew about corruption taking place. And the obvious question that ought to have been asked rather, by those in power, by oversight bodies such as Parliament, is why is this happening and why is nothing being done to stop it happening? Where is the accountability? We have got a range of powerful constitutional institutions with vast powers, and yet nothing is being done. Again, is this mere neglect? Is it mere coincidence that at the time all the events highlighted by the evidence is happening, law enforcement agencies are just asleep? Or is this part of an overall and deliberate project? And the evidence appears to indicate the latter was the case, Chair, and that requires an answer. As the Constitutional Court said, a threat to the fundamental institutions of our democracy. We also have a number of examples, Chair, of the prosecution of persons intent on combating corruption. The Northwest Unit, for example, and its activities.
Your voice is dropping. I don't know whether it's because
yes, Chair, look,
the aircon, maybe the aircon is too high.
Social media pointed that out to me in the break.
Yes.
And it's been reported. It's a habit that I've...
Do your best.
I've built up for over 40 years, Chair. It's difficult to break. My apologies.
Yeah, but I think the aircon is, the noise is just too high. So if somebody can turn it down a little bit, even if not turn it off. Okay.
So we have the contemplated prosecutions of Generals Dramat, Shadrack Sabir. Those were persons investigating the Mkhudli case, the Nkandla case, the Pandey case. There are a range of examples, but they fall under two heads, Chair. quite apart from the inaction and the failure to act, which itself is an important issue that needs to be canvassed, not only with Mr. Zuma, but with others too. The prosecution of persons intent on combating corruption, a range of examples under that head. And secondly, the protection of politically connected individuals from the law. Those two happened in tandem. They were positive acts on the part of law enforcement agencies. So law enforcement agencies were not asleep. They were entirely active. They had in charge of them persons appointed by Mr. Zuma. So it's not enough to say this happened by default, Chair. An active, financed, capacitated series of law enforcement agencies, not one, allowing this to happen under its watch. Again, it's difficult to conclude that this was just yet another coincidence in a train of events that is the subject matter of our terms of reference, Chair, and the evidence laid before you. And it's something that needs to be explained by persons who were in charge. Then, Chair, with regard to the intelligence agencies, you've heard substantial evidence. There was evidence previously from Messrs. Sheikh and Jenje and Maklatuka in relation to the reorganization of the state security agencies under Mr. Zuma's watch. He issued the proclamation creating the amalgamation of state security agencies under one Director General, about which you've heard evidence. And the findings of the Mufamadi panel are stark. If I may just quote this, something again that would be put before the former president. This panel of experts, after serious investigation and deliberation, reached the following conclusion. Our key finding is that there has been a serious politicization and factionalization of the intelligence community over the past decade or more, based on factions in the ruling party, resulting in an almost complete disregard for the Constitution, policy, legislation, and other prescripts, and turning our civilian intelligence community into a private resource to serve the political and personal interests of particular individuals. We are concerned that the cumulative effect of the above led to the deliberate repurposing of the SA. Now, that finding in itself mirrors the evidence that you have of the reorganization and repurposing at cabinet level, at SOE level, in government departments, and here you have the same terminology used in relation to the State Security Agency, and we've heard that evidence in the past 2 weeks. I won't repeat it, but in time it would have been put to the former president for his input, comment, and for his evidence in that regard, because he knew. Now, that finding, Chair, is a finding that says this was not coincidental. It was a deliberate repurposing. The same question then will be asked in relation to repurposing and reorganization in SOEs, repurposing and reorganization in the cabinet, repurposing and reorganization in relation to the Revenue Service, the Department of Mineral Resources, all that evidence that has piled up before you over 3 years. And the question is, are those words appropriate? Is that finding appropriate not only for the SSA, but for all the other evidence that you have heard? That the cumulative effect of the above, all the evidence before you, can only be explained by reference to a deliberate repurposing of state organs, state machinery, illicitly to benefit persons through the unlawful acquisition of state resources. That's the essential question on which we would be concentrating with Mr. Zuma in all its component parts, because it's only when one puts all the component parts together, one asks the question, but didn't this happen in that department? Didn't this happen in that SOE? Didn't it all happen at the same time? Was it not the consequence of a series of events that initiated this process in the beginning? It may be that the conclusion is unavoidable, Chair, but one must hesitate before drawing that conclusion and look at a conspectus of evidence first to see whether it's the most reasonable or only conclusion that can legitimately be drawn. I'm not going to repeat the evidence of the SSA personnel. It's recent and well known to you, Chair, and the public. But what is important too, in particular, is the extent to which Mr. Zuma is alleged to have benefited himself in a way that, according to the evidence, exceeded the mandate, was not part of the mandate of the State Security Agency. Personal protection, the project in relation to money, which we haven't heard all the evidence yet, and we don't know all the evidence yet, but there will be further evidence in relation to payment of those monies, at least to the first stop in the journey intended for that money to the minister concerned, and other projects. One will recall a speech that Mr. Zuma gave to students at a university over a year ago, perhaps 2 years ago, where he emphasized that state capture can only exist if government, the executive, parliament, and the judiciary are all captured or sought to be captured. Well, the obvious answer to that is you don't need to capture the judiciary because matters never get to it. They are halted at the law enforcement agency stage. But it seems that some people thought that that might be appropriate to do. Whether that finally came to fruition or not will be the subject matter of further evidence. But the project did extend far further than just SOEs and particular government departments in relation to procurement. So the allegation would go, and so it would be put to Mr. Zuma. We have evidence of the principal agent network project and an investigation into the activities of that project and its association with Mr. Arthur Fraser. And that, the evidence goes, was shut down on the direct or indirect instruction of Mr. Zuma. That is something that needs to be investigated too. Is this coincidental, or is it part of the overall project? Then, Chair, one has the attempts to influence appointments and dismissals being affected, the consequences of those in government departments and SOEs, the flow, the illicit flow of money and basically the alleged theft of state resources flowing back to particular beneficiaries. One has that. One has, outside of that whole process, big questions that arise over the activities or failures of the law enforcement agencies, from police, crime intelligence, state security agency, the NPA and the like. Questions and many answers that have been put before you. But again, in answer to the question, how could this happen? As you've directed, Chair, one needs to look at the oversight body. How could it happen that Parliament didn't deal with this issue? How could it happen that Parliament failed, or apparently failed according to the evidence, in its own constitutional duty? Those are questions that the head of state needs to deal with so that you can understand, Chair, what the answer is to that question. And there would be an answer, but the answer to that question is either found by you on the evidence before you without answers from Mr. Zuma and co, or you have the benefit of their input. It's a collaborative effort to assist you to meet your terms of reference. It's not a war. It's not an attack on anybody. You want that evidence before you. You've taken every step possible, including steps that might have been seen as conciliatory. But, Chair, this commission is not, as many have sought in defense of their own positions to paint it, as an aggressive, single-minded body that seeks to make premature findings. It has asked all concerned to contribute to its deliberations and has invited or commanded a range of people from all sectors of the community to come before it to assist. You've made repeated calls for people to come forward. The one outstanding gap in the evidence before you is that of the person at the head of the ship, the captain of the ship. It's a great pity you may be compelled to make findings in absence of the person at the wheel of the ship, but so be it. It's not through lack of effort that position has been reached. The regulatory environment.
Well, you were mentioning earlier on about, you were mentioning the stance taken by Mr. Zuma. You might not have referred to him by name in regard to the whole issue of state capture, that he was saying, well, nobody says Parliament was captured or the judiciary was captured. But one wonders within the context of our electoral system and the proportional representation system, or maybe irrespective of that, whether those who may have pursued the agenda of state capture would have said, well, if you capture the head of state, if you capture the president, you know that he is also the president of the ruling party. And if he is powerful in the ruling party, then members of the ruling party in parliament might make sure that the party might instruct them not to pursue certain matters. And therefore, if you capture the president of the country, indirectly you can render even parliament. You can ensure that parliament doesn't investigate matters that it should investigate. And I had evidence about proposals or requests that were made that the Guptas be investigated. And the committee didn't do that. I also had evidence how, despite the fact that the SIU had conducted certain investigation into Bosasa and had presented to the Correctional Services Committee, Portfolio Committee, a report that members of that committee itself found to reveal, I can't remember the adjective they used, or the chairperson of the committee used, to describe how horrific the findings were in terms of the conduct. But nevertheless, nothing was done by Parliament itself, by the committee itself, to stop what was happening at correctional services, between correctional services and Bosasa.
Yes. So there is no doubt, well, perhaps one should not put it that strongly, but there has been clear and convincing evidence that the Gupta family, at the very least, let alone those in charge of Bosasa and other institutions, sought directly to influence or even exercise a degree of control over the former president. That evidence is there. The degree to which he can explain the apparent cooperation that was lent to those efforts through appointments and dismissals, non-prosecutions, prosecutions, and the like. The SSA evidence to the effect that the SSA investigation into the Gupta influence was shut down, that evidence all requires explanation. But there is just one point that needs to be made, that is that this would not have been possible, it may be, only through the influence of one person. That there are others too that perhaps should be called to account in that regard. And that's another issue that needs to be dealt with.
And everyone should recall that early in 2019, I announced publicly that I had a meeting with the current president, and I had indicated that this commission could not be said to have properly completed its job without the executive, members of the executive who served under Mr. Zuma, including him, because he was the deputy president, coming to the commission and saying what they know and dealing with questions that the commission will have. And I said, the ruling party too, this commission cannot be said to have properly completed its job without the ruling party also coming before the commission and say what it knew. When did it become aware of certain things? What steps did it take to deal with those matters of allegations of state capture? And this is important because the party is the one that goes to the voters and say, vote for us. And obviously, usually there is already somebody that they present to say, if you vote for us in sufficient numbers and we are the majority, this will be the president. Now, the ruling party, having had evidence that has been led in this commission, having become aware of a lot of things that we have had relating to allegation of state capture and corruption during Mr. Zuma's presidency, they ought to come to the commission to say, what do they have to say about the fact that they were the ruling party at the time? And this was somebody they presented to the voters to say, this will be the president. And of course, there are other matters that arise in relation to them being the ruling they need to come. Now, I mentioned that publicly early in 2019, that I had mentioned it to the current president, and he had not hesitated to say he would lead the government delegation to come and give evidence. He will give evidence to the Commission.
Yes.
He has never changed from that position. And it's a question of the Commission establishing the dates for that. But he also told me that the ruling party, the ANC, also agreed that it would come and give evidence before the Commission. So they've indicated that. And arrangements will be made for that.
There has been plenty of evidence to answer the first question that you pose frequently, Chair, and that is what happened. But the question that needs to be answered in relation to what you've just said is how could it happen?
Yes.
How could this happen?
Exactly. Yes.
Chair, the picture that has been painted thus far is not the end of the story, and I'll summarize what other elements there are to the picture. The regulatory framework, the banks attempting to close bank accounts because of what were perceived to be dealings fraught with risk and other questions arising over them. Why would Parliament, why would the Cabinet, why would the task team interfere with it? Those are questions that need to be answered. Another question, the Financial Intelligence Centre Act. These illicit dealings somehow ought to have been picked up earlier. Why weren't they picked up? The Financial Intelligence Centre, the evidence has been, gave plenty of information through to law enforcement agencies that wasn't acted upon. But importantly, in the light of evidence that has been given in the last 2 weeks about the role of the State Security Agency, there was an attempt to delay the passing of the Financial Intelligence Centre Act, which would have strengthened the activities of the capacity and activities of the Financial Intelligence Centre Act. But there was also a proposal that would be put to Mr. Zuma that the Financial Intelligence Centre should be moved away from Treasury's jurisdiction into the security cluster. Now, the significance of that on its own is one thing, but seen in the light of all the other evidence, it's significant, and it's something that requires answer. And then, Chair, the importance of what the legal team has termed the narrative. An informed electorate is essential to the operation of the democracy that our Constitution seeks to establish and protect. And to the extent that news or information is distorted, to the extent that the population is misled as to what really is occurring, to that extent, the fundamental aspects of our electoral democracy may be undermined. So serious questions arise as to the attempts to influence the media, attempts to establish alternative and sympathetic media using state funds. All that evidence has been before you with relation to the New Age newspaper, ANN7, the activities of the former president in attempting to deal with editorial policy in relation to ANN7 and the new Sundaram's evidence you will have recalled. That whole conspectus of evidence needs to be put into the picture because the components of what might be alleged to be the state capture project would be incomplete if it didn't have its public relations arm. And there is evidence that indeed it did have a public relations arm, ranging from attempts to influence media, to obtain what is euphemistically called positive news, as opposed to negative news or critical news, to the involvement of Bell Pottinger in its campaign. All that evidence, too, will in due course be collated and put before you, but it's an important part of the big picture. So, Chair, there is more detail, particularly in relation to the lack of accountability that appears to have been a concomitant series of events accompanying everything that you've heard over the last 3 years. In summary, and I'm not going to go through them all because of far beyond my allotted time, and the evidence will come to the fore in due course. But the question of accountability, or the lack of accountability, the lack of detection, action, and accountability is central to the question as to whether this was just a coincidental series of events from beginning to end, or whether it was the outcome was intended and planned as part of what might be termed, you will in due course decide what is state capture and whether the evidence points to that conclusion. Chair, when all the evidence before you, including evidence led and evidence still to come, is considered, at least provisionally, certain conclusions need to be tested, if not made. And those conclusions, provisional conclusions, questions even, need or have needed to be put to the captain of the ship, the person at the wheel, during the period under review, even if they're not final findings. Provisional questions asked. The various appointments and dismissals of ministers, state officials, SOE boards and executives had consequences, such as the corrupt appropriation of state resources on a massive scale. Were those consequences coincidental, or were they intended consequences? Among the beneficiaries of the alleged corruption were the very persons who influenced or attempted to influence the course of action right from the very beginning with National Executive Cabinet appointments and dismissal. Vast amounts of state funds then flowed to a network of individuals and entities, some of whom were associated with the very persons who sought to influence the project or alleged project in the first place. Was this coincidental or planned? No responsible state entity, Parliament, at least for a time, law enforcement agencies, Chapter 9 institutions, at least for a time, until the Public Protector report, were able to, were allowed to, or did detect and put a stop to this pattern of conduct and its various component parts. On the contrary, oversight and law enforcement mechanisms appear, and the allegations are that they were deliberately harnessed to support the project, or at least to prevent it being halted. All this was accompanied by a public narrative, or an attempted public narrative, which attempted to defend and justify what was occurring and to undermine those who opposed it. Chair, this commission has been the victim of that narrative as well, but that's something for another day. Other elements of our society colluded or appeared to collude or are alleged to have colluded in the success of what might be termed a project or enterprise. The auditor's profession, elements of the legal profession. Was such collusion merely passive? Was it a failure to act? Or ought other elements of our society have been called to account in the overall scheme of the evidence that is presented? And in the end, Chair, Mr. Zuma, through, and I stress, honest cooperation, might have assisted the Commission to understand fully not only what happened, but how it could have happened.
We are at 25 to 1. You are done. I'm thinking that whether we should, I should say something now until we finish, or whether we should rather take the lunch break and we come back at 2. So before I announce what the Commission is going to do about what has happened, have you got suggestions?
Chair, considering the circumstances and what you as Chair would say about the non-appearance today and its outcome and consequences, they're significant. And it's not for me to say, Chair, but some consideration perhaps ought to be given. Although, Chair, on the other hand, the consequences seem to be fairly clear.
No, we are very clear about what needs to be done. There is no confusion about what should be done. Our law is not deficient in this respect at all. But it might be appropriate to adjourn and then come back at 2, and then I'll make my remarks about some of the matters that have been raised, and then announce what the Commission, what next the Commission will do.
At 2, Chair?
Yeah, 2.
Thank you.
We're going to adjourn and we'll resume at 2 o'clock. We adjourn.